AI&Law webinars number 9. Good afternoon or good morning, good evening, all depends on your time zone. I am your co-host, I am Yannick Manesser, and it's my pleasure to welcome you. In this new edition of this series of webinars, we will take a close look to one of the hottest topics of the moment, facial recognition and its use in criminal justice. Hello, Juliette.
Hello, Yannick. Hello to everyone, and welcome also from the University of Strasbourg. I will start with presenting our 3 experts for today. Our first expert is Thomas Lampert, who is the chair of Data Science and Artificial Intelligence at Telecom Physics Strasbourg and iCube, which is a very big lab at the University of Strasbourg. His research focuses on theoretical aspects of AI and its application to real-world problems. Thomas has held various positions in the industry and academia in the UK and in France, and has acted as a consultant to several companies. Our second speaker is Kate Robertson, who is a criminal law barrister in Toronto. So good morning, Kate. She also holds a fellowship at the University of Toronto Citizen Lab, where she consults on law and policy issues relating to human rights and law enforcement surveillance. In 2020, so last year, Kate co-authored a very interesting book, To Surveil and Predict, a human rights analysis of algorithmic policing technology in Canada. Finally, Sabine Gless, who is a professor of criminal law and criminal proceedings at the University of Basel. Her research and writing analyzes the impact of artificial intelligence on criminal justice systems. She works on predictive policing made with AI and on the question of AI in the courtroom. Sabine is currently the leading investigator in a project on legal challenges posed by big data, funded by the Swiss National Research Foundation. So thank you to all 3 of you for joining us today. We will look at a short video to introduce our session. Right now.
Yes, let me try. I will broadcast you an excerpt of Sky News about facial recognition.
It has trialled the technology, now it's to begin using it for real. Scotland Yard says facial recognition cameras will be vital in spotting criminal suspects and missing and vulnerable people. Police say the system won't retain images of anybody not on a watch list.
Every image that is looked at by the technology, if there is no match, it's instantaneously deleted. So it's a momentary comparison. If it's not a match, it's instantaneously deleted. The only images that are retained are those where there's been an alert, and they are retained for a maximum of 31 days.
But privacy campaigners say the move is a stain on the new government's human rights record.
Never before have members of the public been treated like walking ID cards subjected to an ongoing police lineup, that our identities have to be biometrically checked to make sure we're not criminals. That's a complete inversion of the traditional presumption of innocence that is so at the heart of British civil liberties. And that's why I think this is none less than an assault on our rights.
Police say the technology works like this. The faces of anyone not on a watch list appear pixelated. This is what happens when a suspect above is caught in the crowd below. The potential match alerts officers on the ground, and they decide whether to approach the suspect. At least 3 police forces have been piloting the technology. Here, the South Wales force used it to monitor football fans. When one passer-by challenged its use, the High Court backed the police. There are conflicting statistics about the accuracy of facial recognition technology. The Home Office said it fully supported police in its use. Martin Brunt, Sky News.
This is a very short introduction, and I think in that video you find already some good questions that we will tackle with today with our guests. Please allow me to invite you to use also the chat function of this webinar, where I will gather some questions and we will raise them a little bit later. And I will also use a poll on this webinar, meaning that I will ask you a question and feel free to answer to it, just to have your advice and to interact with us. So it's my pleasure now to give the floor for the opening to my director, Jan Claessen. I do not see if Claudia Luciani is connected yet, but Jan, we begin with you, and the floor is yours to open this webinar. Thanks a lot to be with us.
Thank you very much, Yannick and Juliette. Good afternoon, everyone. Very welcome to this very interesting webinar on the challenges posed by facial recognition to human rights in particular. And I would also like to thank our three eminent experts who have kindly agreed to share their insights with us. I will be very brief because everyone wants to hear the experts. Just to put this webinar in the context of what the Council of Europe is doing on artificial intelligence. We are working, and I think this is unique in the world, on a possibly binding legal instrument, i.e. a treaty, to deal with high-risk applications of artificial intelligence. And facial recognition is certainly such a high-risk application, as I'm sure will become abundantly clear in the course of this webinar. For those who would like to know a bit more about our work, and the relevant committee is well posted behind our moderators. It's called the CAHI, the Ad Hoc Committee on Artificial Intelligence, which you see on the screen. It adopted a feasibility study in December, which is public and which you can find on our dedicated AI site, in which it recommended that work be carried out, as I say, on a possible treaty, as well as on non-binding legal instruments in Council of Europe talk, which means policy recommendations and guidelines. And in the field of facial recognition, only last week, guidelines were issued by our Committee of the Parties of the Data Protection Convention, about which Sophie Kwasny will tell us more in the course of this webinar, pointing to the need to ensure that privacy and the rights guaranteed by Convention 108, that they be guaranteed when governments resort to facial recognition. I think the issues have been set out in introductory paper to this seminar. We have the clear cases of discrimination. There are clear cases of wrong identities, as was just said also in Sky News, in the Sky News excerpt. We have, of course, extreme forms of video surveillance that are reported from China, with social credits being allocated to people's behavior and around-the-clock monitoring. So a lot of issues, and obviously a lot of issues with regard to human rights, rule of law, democracy. So I look forward to listening to our eminent speakers, and I wish you a very productive webinar. Thank you all very much for being here.
Thanks a lot, Jan. And we don't have news for the moment from Claudia Luciani. We will connect her as soon as she joins us, maybe for the closing. We will see. Juliette?
Yes, thank you very much, Jan. And we'll immediately give the floor to our first speaker, Thomas. Do you hear me, Thomas?
Yes, I do. Hello.
Yes.
I just share my presentation. You can see my slides?
Yes, very good.
Okay. Well, thank you very much for inviting me to give this talk. So I'm going to give a brief overview of the technology behind face recognition, but without going into too many technical details, and give you some ideas of where this can go wrong or where it can be fooled into identifying somebody incorrectly. So first of all, we have face recognition, as you've seen in this video, monitoring videos, CCTV cameras, or detecting in images. So the first task of the system is to detect whether there is a face in this video or in this data stream. Once a face has been detected, then the next stage of identification can occur, in which either a specific person can be identified, so you could have a model trained to detect me in a video, or in a one-to-many case, it might try and summarize the face seen in the video or image, such that it can be matched to a ranking of people. So the first person should be the most likely person, and then you can get the similar faces from a database, for example. The most state-of-the-art system to do this at the moment is deep learning. Probably some of you have heard about this kind of technology. This has revolutionized AI and machine learning in the last 10 years, let's say. So these models are loosely based on how our visual cortex works and how our brain works. So they're deep because there are many layers, and we'll see about those in a second. And so the first task is to define the structure of this network. Essentially, how many layers you see here. There's this image with the connections between the layers, things like this. So this is our model, and then we collect a large data set of faces. Obviously, this can be done from social media or from a database, an existing criminal database. There are many places where we can get face databases made, and then we need to train the model to recognize faces within that. What does that mean? So initially, this model is kind of random. You put a face in the first layer, and in the output of the model is some random decision. It doesn't mean anything. But we want to train it. We want to train it to identify somebody. So the most kind of intuitive example I could think of this in a real world that people might be familiar with, without going into technical details, are these kind of games, these kind of slot games that you have in fun fairs. So here you have an input to the model, which is where you're putting the coin in, and you have an output, which is where the coin ends up. And in the middle, there's some structure, and that affects where the coin goes. And in this state, it's kind of random where the coin will end up. So if we imagine that we want to put a certain type of coin in this, and we want to affect where it might go, then we could imagine that we can move around these pins in the middle, add some more in, remove them, and therefore we might have one type of coin ending up in the bottom left and another type of coin ending up in the bottom right, by the way the structure is. And this is more or less exactly how these training of deep neural networks work. We have the image as an input, and we change the structure and the weights and the parameters of the model, such as the output gives us a certain result. And then if we know that we put a small coin in and it ends up in the bottom left, if we have a coin in the bottom left, we know it was a small coin. And it's the same for faces. If the model outputs a certain set of numbers, then we know that the face is a certain face on the input. And in face recognition, we can train this in what's called a triplet loss, which sounds complicated, but it isn't really. We just have 3 faces. We have 2 here of Barack Obama, and we put them in the model. And what we tell the model on the output is to say, make the output of this model, when we put 2 pictures of Barack Obama in, to be similar. And then when we put another face in, the output is very different. And then we can use that to distinguish, okay, I see a face in a video, I put it through my system, and then I find in my database the closest face to that, because the output of the model should be similar. So using this to train a face recognition system, we can get very accurate results. In the video, it says it's disputed, and it is, depending on the conditions of the video. But generally, on a nice, clear image, Facebook can achieve 97% accuracy, which is more or less the same as humans on the same data set. And Google, we can get 99% accuracy. These might be a few years old, so it might have even increased from this. And there are some tests where they've benchmarked or validated several face recognition algorithms. And the best algorithms get an error rate of 1 in 1,000 images. So with these deep learning models, we can get very accurate detection mechanisms if the data is nice and clean. One thing with machine learning, though, is that they can become brittle. And brittle, I'm going to show you some examples of this in the next few slides. So although we get very high accuracy, they can be broken quite easily if you have a bit of knowledge about the system. And that's what I'm going to talk about now. So a nice example of this is, in face recognition terms, called an evasion attack. So this is where you might use what's termed as an adversarial example, and we'll see what that means in a second, as an input to the model, and is designed to cause a misclassification, so designed to be identified as the wrong person. So here we have an object detector which uses a deep learning model, which is pretty much exactly the same as a face recognition system, and it recognizes a pig with 91% confidence. So what we can do to this is we can modify this image slightly, but modify it in a way that a person does not see that this image has been modified. So we can add some special noise to it, and we can calculate what that needs to be. And then this picture gets identified as an aeroplane with 99% accuracy. So we can cause the model to detect the wrong person. Now, of course, this may not work in a real system because you're actually affecting the image that goes in. If you're walking in the street, you can't affect that image because it's caught by a camera in a closed system. Maybe somebody within the system could affect that image. But in real world, we can do similar things. So here, there are researchers that have showed that we can 3D print some glasses here with certain patterns on them in real life, and I can walk down the street with one of these glasses on, and I could be misidentified as another person by the system. Furthermore, a more complex attack could be that I can mount lights on a hat that projects a small infrared pattern on my face, which is less easy to detect in the image, and then this can cause my face to be misclassified here as the musician Moby. So here we can use in real life systems or stickers and even tattoos or earrings that cause a face recognition system to misidentify the person. Even more extreme, we can actually make the person disappear according to the system. Here, this man is wearing a jumper with a certain pattern printed on it, and you can see there are smaller people here that are further away, who you would think would be harder to detect, and they've been detected with the blue boxes there. But this person doesn't appear to be a person to the system just because he's wearing this jumper. Of course, as we saw in the video in the introduction, generally these images are verified by somebody. It might not always be the case. For example, in the Chinese system where there are social credits, I imagine that these are quite automatic and there wouldn't be too much verification. So if I was to appear as somebody else, I could affect somebody else's social credit, for example. So they wouldn't stand up to human verification, and they do require knowledge of the system. But some systems are based on pre-trained models that exist online, so I might know how to affect that model. So perhaps this is a bit more technical and academic rather than realistic, depending on how the system is used. But there are other ways to affect the model. So we saw we need to train the model with a larger data set. Machine learning algorithms are data hungry nowadays, especially deep learning algorithms. And so the data is collected from many different areas, from social media, traffic cameras, CCTV, etc. And what actually can happen is that instead of affecting the image that is put through the model to identify a person, I can affect the training data of that model. And this is called a poisoning attack or a backdoor attack. And so I can alter one of the images as the input. For example, in the next slide, you don't see that there's anything changed in this image. So this is called a clean label attack. So this image has been altered in a specific way. And once that is in a training set of the data set of the model, this person cannot be identified by that model. And it generally works for different models. So basically, if you're putting images, and this is an open source system, you can find this online. If you're putting images on social media, run them through this first, and then any law enforcement who are trying to train face recognition systems using people's social media profiles won't be able to identify you in these systems unless they get around this type of system, of course. And it's even more extreme in this case. An attacker could embed some kind of information in this image that's undetectable again, at least by looking at it, that causes other images when you're using the system to be misclassified. So I could put an image of myself with some noise in the training data set, and when it's tested, perhaps another person is misidentified as something else because I've somehow corrupted the way the model learns there. So this can be quite extreme. So if you have control over the system, you can alter the way the system works. And then the ultimate way of generating, of fooling these kind of systems is with deepfakes. So you might have seen these in the news recently, but it's very possible to either take an existing video of evidence, say there's a crime committed, there's a CCTV camera. If you can run it through this system, you can inject a face onto that video image, and then you can run it through a face recognition system, get the wrong person, and also you have the evidence that this wouldn't stand up to human scrutiny at the end. And you could even go even more extreme, possibly nowadays, but certainly in the future, you'll be able to generate a whole video from nothing and create evidence with a person in it and have them accused of the crime, potentially. So this is how we can fool systems intentionally by a malicious attacker. There are other ways that facial recognition systems fail at the moment. This is a bit more perhaps serious in real life at the moment, is that the data sets are quite biased towards researchers in Western countries. So these models do tend to work better for white Caucasian people rather than Asian or African American people. And this has a big problem. It has been shown that systems trained on FBI databases are more likely to falsely identify a black young woman for a crime rather than the true perpetrator. So it's more likely, if you're a black young woman in America, that if the law enforcement are using these systems, that you can be falsely identified. And moreover, there are online services where they crawl the internet, taking public photos of people from their social media. And there are services that the law enforcement use that the FBI or whoever can use to find a person online for that. So you're more likely to be falsely identified for a crime in that case. However, there is light at the end of the tunnel. The least biased models tend to be the most accurate models. So really a simple fix to this is to have data sets that are better curated and pay more attention to this. And definitely researchers are working in this direction, and there are conferences specifically on this point. So this is something that will be resolved at some point in the near future. In the meantime, there are recommendations, for example, in forensic scenarios, where you should train individual models on certain demographics. So you might have a model for identifying a black male or a white male, and use the specific model depending on who the perpetrator is and that you want to identify, and that should reduce the bias in the system. So to come to my conclusions on the talk, face recognition is in general very accurate, especially using deep learning models, but it's also susceptible to bias, poisoned attacks, and adversarial attacks. It is possible, perhaps through audit and certification, to certify whether an algorithm is immune to these kind of attacks. One of the problems for adversarial attacks is that it's possible to stop a model being susceptible to an adversarial attack, but there are many different types of attacks, and it doesn't necessarily work, therefore, for all attacks. So you would have to have a certain certification for each type of attack, and there could be more generated in the future. It's like hacking into a network. There's always somebody who can find a way to do it. And just a small note to end by is that this isn't just relevant to face recognition. This works for autonomous vehicles or other ways that deep learning models are used currently. So imagine the consequences of putting an adversarial patch on a stop sign in the street and stopping an autonomous vehicle from being able to see that stop sign, or a speed sign or something like this. This can become very catastrophic in the streets. So I finished my talk there. Thank you very much.
Thanks a lot, Thomas, for this brilliant and very clear presentation. I'm pretty sure that you learn a lot to a lot of people about that, because we are discussing about artificial intelligence, but sometimes we don't understand what is behind. Mm-hmm. To sum up, what I can share with the audience is that it's basically made on statistics. There is some issues like adversarial examples that you show with some kind of noise in the picture, and there is also some kind of solution. And Sophie Kwasny will discuss a little bit later about the certification or audits. We find this solution in the very recent guidelines that have been published. But I have a question, and I will introduce Kate Robertson, maybe to present her views about that. But I have a strong question that came from this Gabor law. Gabor was a Nobel Prize. He said because we have a technique that we have to go in depth in that technique and use it. And my question is it because we can do something that we must do something? It's a question, and I'm not sure that because we have facial recognition that we have to use that in all situations. Kate Robertson, it's my pleasure to welcome you, and I will give you the floor now for your presentation.
Thank you very much. I'm happy to pick up in this interesting discussion following Thomas's very clear and cogent explanation of some of the technological advances as well as some of the remaining risks associated with facial recognition. As it was introduced, I am a practicing lawyer in Toronto. I practice criminal defense law. I also am a researcher at the University of Toronto and have examined a range of AI-driven technologies that are being put to use in Canada by law enforcement services, as well as technologies that are being experimented with. And these are very similar to some of the technologies that we've seen being deployed by police services in other countries outside of Canada as well. As a researcher at Citizen Lab, I was happy to join up with colleagues at the International Human Rights Program in this work because it is very clear to us, both at the outset and now after having published the report, that drawing on international experiences, including international human rights law, will be a very important source of guidance for governments as well as police services in examining many of the human rights risks associated with AI policing technologies, including facial recognition. And this is because many of the traditional legal frameworks in Canada and potentially elsewhere are not yet equipped to address some of the more complicated issues that come with AI policing programs and as those programs are used in criminal justice. So, you know, in a very general sense, Thomas has introduced facial recognition as a technology that we're all now becoming familiar with through the media as well, and other notorious examples such as Clearview AI. And we understand generally that police services may seek to use facial recognition to de-anonymize or identify somebody that is visually seen on some form of either video footage or camera footage, but their identity is not known. And as we approach this technology from a perspective of human rights law, it quickly becomes clear that it's not sufficient to define the problem too narrowly. So if I could provide an example, a police service, including ones in Canada, have suggested that facial recognition is very useful in an example involving, let's say, a bank robbery where you have video footage that depicts somebody coming to rob the bank, but we don't know who they are. So perhaps the technology might be useful in an investigation to identify a suspect and continue the investigation from there. But of course, when it comes to human rights law and examining the legality of a technology, it's too simple to answer the question of whether or not a technique is useful. And if I could provide a contrasting example, perhaps 30 or 40 years ago, we might have been having a similar type of discussion about whether or not it is useful or lawful to have a law enforcement or police service intercept telephone conversations surreptitiously or in secret. And that, no doubt, is a useful law enforcement technique, but it's a much more complicated question to identify what makes that type of technique lawful and what makes it that the technique compliant with international and domestic human rights standards that are at a very important level when it comes to criminal justice proceedings. And so it's much better to understand the question of legality from a perspective of trying to understand and unpack what are the many preconditions to legality that we need to define to address the unique issues associated with facial recognition technology. And so one of the questions that Thomas focused on is this technology accurate? Is it going to create risks of wrongful arrests? And that's certainly an important part of the conversation, but it's not the only part of the conversation. And I'm going to try to elaborate some of the additional risks that lawmakers, governments, and police services must be aware of in identifying what the preconditions to legality should look like in the 21st century. We know that wrongful arrests, including the arrests of Black individuals, have already taken place. That has happened in my country as well as in the United States, as I understand from media reporting. The chief of police in Detroit just last year described that their own facial recognition system misidentifies individuals 96% of the time. So risks of misidentification are very much a part of the current state of affairs with the technology as we understand it today. But if we could turn to some of the other dangers that are at stake. Firstly, one of the problems that I'm seeing as a researcher in Canada, and I suspect elsewhere as well, is that many of the facial recognition systems that we know are being used are not showing up in courtrooms, and it's difficult for judges to obtain opportunities to provide a ruling or guidance as to the legality of the technique. There was an important ruling from the United Kingdom's Court of Appeal that actually had the opportunity to examine the legality of a facial recognition program in England, and it found that the program was deficient in a number of ways. We haven't had that opportunity yet in Canada. And that goes to one of the unique issues associated with AI, is that they present access to justice problems because many people in the community are susceptible to these AI systems but have no opportunity to challenge them in court or even to know that they've been affected by the technology. And because these AI-driven technologies are being used by police services from within their own police stations at a police computer, it appears to be the case that police services are using these technologies often on a secretive basis with little public knowledge or awareness. And this is because they don't need to reach out to other private companies, such as a telecommunication provider, in order to obtain information. It's information that is being analyzed and processed from within the walls of the police station. And so it's that much more evasive to democratic and judicial oversight. One of the key questions that we want to think about when we're examining the impact of technology like facial recognition is to think about what the impact of the technique is on the society as a whole. And so in Canada, as in elsewhere, we define legality by definition of balancing the various public interests that are at stake. One of those critical public interests that we currently enjoy, in which facial recognition will undermine, is anonymity and freedom in public space. Currently, individuals and groups are able to participate in public protests, including online and in real-world environments, with the freedom that comes with a sense of anonymity of your identity. And the erosion of that anonymity is something that we might want to think about. Well, what will that look like in 30 years? How will that affect other rights in addition to privacy rights, such as the freedom of expression, the freedom of assembly and association? And from an equality perspective, examining how those rights are more likely to be undermined for equality-seeking groups who are more dependent on access to public protest in order to have their interests heard by society and by governments. We also need to think about other areas that are now under-regulated as a result of the emergence of facial recognition. So, for example, police services have enjoyed quite a bit of discretion with respect to the collection of video footage from private companies or from cameras that are erected on the lampposts of an urban environment. And so regulations with respect to the deployment of cameras in cities, as well as the collection of images, now needs to be re-examined. We also need to look at the regulation of the use of biometric information. And this is a trend that I've seen in many cases where, because police services can use a technology relatively easily, for example, Clearview AI is a technology being marketed on a trial basis to law enforcement services around the world. However, these technologies are being deployed without the accompanying infrastructure from a data protection and compliance perspective. And so you have an inability to provide data protection within police services that's sufficient to the task and to the dangers that are at play. For example, mugshot databases, they're currently under-regulated in Canada, and they're also rife with many of the biases that we know are rampant in criminal justice processes historically. There was a recent report in Canada, for example, that talked about how the arrest statistics are particularly biased when it comes to racialized communities. And so those mugshot databases themselves need to be examined for bias and discrimination issues. And so generally speaking, when it comes to some of the takeaways from some of these potential problems, we as researchers identified that there are probably three core principles that lawmakers and law enforcement services will want to think about when examining what is the regulatory landscape need to look like before something like facial recognition can be safely deployed in a human rights respecting manner. Those three core principles are the following: reliability, necessity, and proportionality. And each of those concepts have an integral role in understanding whether or not, in conducting a balancing exercise, particular technique, in AI-driven technique used by police is compliant with international human rights standards. And so we examining the current technology from the perspective of reliability, necessity, and proportionality, we may find that in some cases it's too unsafe to use at all. And it's not simply a question of whether or not it's useful in a particular investigation. And I'd also like to draw attention finally, before I pass the floor over, to also examining what systems of oversight are necessary to respond to policing programs as police services tend to or seek to use AI technologies. Traditional types of oversight in criminal justice have focused on warrants, which is when a judge provides a very specific authorization in a specific case. The United Nations High Commissioner for Human Rights has emphasized that when it comes to mass surveillance technologies, that really every level of government needs to play an important role when it comes to oversight, in addition to judicial warrant processes, because The rights of the community are very broad. It's not individual defendants alone, and criminal justice responses may not be up to the task of fully protecting the gravity of the rights that are at stake. Thank you very much. I'll pass the floor back over.
For this excellent presentation. Thank you for reminding us of the three core principles: reliability, necessity, and proportionality, which means that, of course, the police cannot be alone with deciding on whether using or not using a technology, but reminding us that the judicial authority has much to say about that, and that our criminal justice systems should now really seriously think about introducing a judicial judgment and a judicial intervention in the use of this technology. So thank you, Kate. Thank you so much. And now we'll come back to Europe, to Switzerland. Sabine, do you hear me, Sabine?
Okay, so thank you. I can't see you now. This is not my computer, but I think it will work like that. So thank you, Juliette and Yannick, to put this together. And I have been introduced as a criminal justice person, so I will give the criminal justice perspective. And I think one of the topics coming up in both of the presentations is the question, suspicion now created by artificial intelligence. What would be a reasonable ground for suspicion in a liberal democracy? And now, as a criminal justice person, if you look back, one must admit that suspicion always has been subjective, humanly subjective, often biased, and our expectation is it won't change that much with artificial intelligence. So if we try to find something in the law that could help us, we can turn to the case law of the European Court of Human Rights that has some important judgments on what is a reasonable ground for suspicion. And the judgments hold that it's the pre-existence of facts which would satisfy an objective observer that a person may have committed a crime. Having listened to Thomas, we know that there is facts in recognition programs, however they are engineered, and I think both presentations have shown what are the risks of this engineering. So I think, and I think that will come up in the discussion also, we will have to conceptualize new bulwarks against in safeguarding humans who might be subject to over-policing because of facial recognition. And I think in the video we saw at the beginning, one of was already mentioned, and that's the presumption of innocence. From a criminal justice perspective, that's a very important safeguard. However, and I think Kate made that clear, it's very individualized. So it rather helps the individual, but it doesn't really give us an answer as a society. I think as a society, we have looked to the principle of equality before the law that ought to protect us against over-policing. But how that will translate into solid legal rules, we don't know yet. What we know, and that's why I called my presentation now automated suspicion and then evidence. I would like to take you and AI to the courtroom. What we know now and what we see all over the world is that police and prosecution service, they use tools that automate suspicion. And I have brought you some slides that show that we find that everywhere. So this is a German newspaper where the German police thinks about what police in UK does, and that actually is the facial recognition program we have seen at the very beginning. But we can see it, for instance, in Australia and the Netherlands. Now the police uses what they call smart cameras. This is cameras that take pictures of mobile phones or take pictures into cars where they suspect that the drivers use mobile phones. Now again, if you think back at the presentation of Thomas, you can see there might be some bias in that program too, because it will be very much more easier to spot a mobile phone if you wear white clothing than if you wear black clothing. So only a certain kind of dressed people will be caught. We also see that a lot in the US. This is a breathalyzer who made it to the press because it's a breathalyzer that is digitized, and it's very difficult to challenge the results if you go to, even if you go to court. But it's usually you don't go to court, you said with a plea bargaining, and that's why the reporters make the claim, these machines can put you in jail, don't trust them. The area where mostly artificial intelligence tools are used now for prosecution is actually white-collar crime. It's automated auditing, and that goes for nearly every country in the world, that AI looks at the money trail, they look at banking accounts, and they have become quite good at identifying kickbacks, seeing the pattern for corruption. And again, these tools might be biased, no one knows, and Kate pointed that out. Very often you will not see that in the courtroom, but it's only the first lead and then the real prosecution process starts. But sometimes these AI-driven tools, they can be both. You, if you would want to, you could use smart home devices, for instance, Alexa, to automate suspicion by listening to certain words. But you could also, and you know, perhaps that has been a very prominent case, you could also think about using it as real evidence. That was a case in Arizona where the police came in the morning. They had a young man dead in his bed and in a whirlpool, and the other young man was sleeping in the bed, and they wondered whether they could question Alexa and ask what happened at night, and could you please repeat? Now, if you're interested in that, we might come back to that in the discussion. The example I want to use today, because it's an example that many of you will face in your daily life, only a few years to come, is the question whether you could automate suspicion or evidence during an automated drive. What is an automated drive? An automated drive, you see here 5 levels of driving, would be level 3, level 4 driving, when you are allowed to hand over the steering wheel to the car. You see that here, that's a traffic jam pilot. So in a traffic jam already, there's a lot of devices that could actually steer your car, and then you can do something else. Now the tricky point is that an accident could occur, and then the car wants you to take back the steering wheel. And that's why the car driving assistants constantly monitor the human. And perhaps the car that you drive already has such a device. It's called a driver attention alert. When the car has the impression that you do not pay enough attention, it will start to illuminate the coffee cup, and it will start to beep. Now, if you think back to Thomas' presentation, you will realize could be a lot of bias in this instrument. And I put Richard Gere here because he has these eyelids that are not clear whether perhaps if you would use a dash cam and look at him, the car might think that he's sleepy just because of the shape of his eyes or his relaxed body in the seat. Also, the seat will monitor the person. And my argument for today is that the more we will share our driving with driving assistants, and here that's my coded driving assistant, that's the person that does not appear on this automation levels that we usually use, that if an accident occurs, one of the two is to blame. It's either the human or it's the car. Very rarely we will not blame anyone. So I think we should look at this driving assistant and think about whether this person, this new driver, could be a witness. We could use him also for automating suspicion, but we could maybe also use this person as a witness in a trial. So that's the argument that driving assistants that monitor human drivers, especially for takeover requests in a certain situation, they store certain steering movements, they monitor signs of drowsiness, and they document the observations. And the question now is, and we had cases like that in Switzerland already, can we use this automated evidence? Usually it's called machine evidence, or some call it robot testimony in the criminal court. And then the two things come up that already Thomas and Kate indicated. Can we assert or challenge trustworthiness? And can we evaluate fairness of this machine evidence in a criminal trial? Now, if you think about, can we use it, this robot testimony in a criminal court? Normally what we would do is we would appoint a human expert, and we would expect this expert to translate the meaning of the data that is stored in the events data recorder, or now that's very technical, but probably we will have a data storage system for automated systems for the drowsiness detection system. And this expert would explain what it means. And so this is one of the problems that also Thomas and Kate already pointed to, that the human on the ground, the police officer or the judge in a courtroom, they will not have the expertise to actually know about the flaws of the system. They will always need an expert different to the analog world, where they might be able to see the flaws. And there is now more and more scholars who think that it will not be enough to have an expert in the courtroom, that what we actually need is to hear this new witness and to cross-examine the robot witness in the courtroom. And I think in Europe, we have a very strong argument to actually ask for that, and that's Article 6, paragraph 3 of the European Convention on Human Rights, which is known to all of you, that everyone who is charged with a criminal offense has the following minimum right, and that's the right to examine or have examined a witness against you. And then the question is, who is the witness against you? And I think there's a strong argument that you can say that in those cases with drowsiness detection systems, it is the drowsiness detection system. And the next questions would then be, how would you ever question that? And then there is some suggestion for that, that perhaps you can analyze from design machine learning, just the way Thomas showed us, average, auditing. And the big problem is, how will you address this black box problem that we have seen in Thomas' presentation, the deep learning, where you cannot in one, will not be able to explain why the drowsiness detection system issued an alert in a certain situation. Now, some of you might think, well, that's very long into the future. For those, I have brought with me a reference to regulation that was adopted in 2019 by the EU Commission. And in that regulation, Article 11, there's a listing of all the specific requirements related to automated vehicles, or even fully automated vehicles. That's what Thomas mentioned before, self-driving cars. and they all ought to have a driver availability monitoring system in a time window that starts 2022 to 2026. New cars will have that, and then we will have this robot witness in our car with us. Now, I hope that some of you are more interested in these problems that I have only sketched very briefly. And for those, I have brought some literature that takes the argument a lot more in depth. And I think since it is recorded, perhaps one or two of you could have a look at that. Thank you. I will stop sharing the screen now, and then we can start the debate. Thank you.
Thanks a lot, Sabine, for this insightful presentation. And clearly, just you said many things, but what is very interesting for me is when you say that there is a need of experts in courts. And as a former judge, I can tell you that a lot of colleagues, indeed, even for new technology in general, sometimes we need support of experts. But with these technologies that are not clear, that are black boxes also, it's very difficult really to have a clear and balanced criminal proceeding with that. And thanks a lot to mention that ICHR and our convention is already a standard that could help to support human rights. Juliette, maybe we can use and try to get some questions from the audience at this stage, and we will have then the chat with our guests also. So just, there is several questions, but I will raise one from Gaëtan Goldberg, which belongs to Défenseur des Droits in France. This is an institution that promotes, of course, rights. I just quote his question. Many experts, as well as former UN Special Rapporteur on Freedom of Expression, David Kay, underline the chilling effect real-time facial recognition technology could have when deployed in public areas. How would you go about and measure such a chilling effect on fundamental rights, such as the right to protest or the right to assembly? Wouldn't numbers help in demonstrating the lack of proportionality in deployment of this kind of tech? So, to sum up, a question about this well-known chilling effect and the use of facial recognition. Tom, maybe to take the order of the speaker. Tom, a very short thought in 2 minutes about that, about this effect of facial recognition.
Yeah, it's a very interesting question. I think Kate touched on this during her talk. As a scientific person, I would be very interested in calculating numbers, although I'm not a sociologist, so it would be very hard to design such experiments because you have to monitor protests that are spontaneous. I really don't know from a social point of view how you would design such experiments. But I completely agree that the AI systems should be regulated in this way. And personally, I don't really like the fact that an AI system can be used in such a way that would make me feel uncomfortable walking down the road. So I believe that there should be some studies, and there should be these results of these studies should be used to guide the way that these systems are used or where they are used. And I think, moreover, Kate touched as well, is that there are companies just collecting this data, not only publicly in the streets, but online. Pictures that people post online are just being collected in exactly the same way, and this might affect the way people can express themselves freely online, not just in the street. So I think there's two aspects to that. In terms of how it would go about, I think I have to leave that to somebody who's a bit more experienced in that domain of things.
Yeah, just complementary point of view. Kate, you already mentioned that. How can human rights could help to frame the use of such a technology?
Well, certainly I can do no better than the Court of Appeal in England that has already weighed in on this very important question. It's a very good question because it highlights that facial recognition technology is capable of being used in multiple ways. And just for the audience, it's helpful to understand that I believe the question's being asked in respect of a technology that enables essentially a police service or law enforcement body to erect a camera at a public location, which is automatically equipped with de-anonymizing facial recognition, so that at the very same moment that the camera is watching, it is also processing the faces that it captures and connecting them with a particular image database, so that there is no gap between the collection of the image and its processing through the facial recognition technology. And if you know the saying, from a privacy perspective, this is the equivalent of a 5-alarm fire, because it has such dramatic consequences that are unhindered by any kind of contemporaneous restraint on the use of the system in respect of which faces it's capturing. And so it's an unreasonable infringement on human rights to deploy this technology, because it is not sufficiently necessary, targeted, or proportionate to the human rights that are at stake. And that is a very general summary of what the judgment of the Court of Appeal in England found when it examined the use of automated facial recognition in South Wales in the United Kingdom. That type of technology, we believe, is not currently being used, and we understand that in my home province, for example, the Toronto Police Service has been advised by Crown prosecutors that it would be illegal to conduct this type of technology.
Thanks a lot, Kate. Sabine, about this chilling effect, and we have also another question on the chat about privacy, but I will save that question for Sophie Kwasny afterwards and the chat. But what do you think about that? There is a direct effect of facial recognition, but also indirect effect. How we tackle with that?
First of all, I think the chilling effect is clear, and every one of us could feel it. If you think about going to a demonstration and you have the risk of being arrested, and you know that your face will be monitored. So I think, it's quite clear to me. So how could we face it? We had this debate about predictive policing. How could you actually face it in a criminal justice setting? And I once proposed that, what we should have is an exclusionary rules taking effect in criminal trials where a defendant can prove that he has been over-policed, that he's part of a member of a group that always sticks out. Because, that's one of the basic problems of automated suspicion, artificial intelligence. We now have a plethora of suspicions, and someone has to decide who will have to stand trial. And if you want to know one thing from criminology, it's if you have a look, very often you find something. So if you're if you're a member of a group that is policed a lot, you have a very high risk to go to court. And so I think if we really want to face it in the criminal justice system, we would have to make that part of a criminal trial, regardless whether the person is guilty or non-guilty, look at was there any over-policing. But I think politically, that's a criminal justice proportion. Politically, this will be very hard to push because if we find someone who is guilty, our criminal justice systems think it's fair that this person also should be prosecuted.
Yes, all exclusionary rules are quite difficult to implement, and maybe even more difficult in continental countries. But thank you very much to all three. And we'll now turn to a question raised by Sophie Kwasny, who's the head of the Data Protection Unit at the Council of Europe. So it's not a surprise that the question will have to do with the data protection perspective. Sophie, are you ready to take the floor?
It would seem so, if you can hear me.
Yes, please.
Hello. Hello, Juliette.
Very good.
Hello, Yannick. Hello, everyone. Thank you to our great three speakers for their presentations. And if I may, because I have a chance in putting my questions to the speakers, also to speak about our work that is of relevance to this topic, and maybe start one level higher up before going to facial recognition and criminal justice. Just speak first about data protection and criminal justice, or privacy and criminal justice, because I think it's very important to recall that the right to data protection, the right to privacy, is not an absolute right. You can bring restrictions, limitations to the right. It's the whole question of balancing fundamental rights and interests at stake. There are, of course, very strict conditions to bring those restrictions and exceptions. I think Kate has brilliantly mentioned those already. Indeed, strict conditions for those exceptions to be lawful. So on the one hand, we have governments having a duty to protect us. On the other hand, we all have a right to data protection and privacy. So how do we get the balance right? Knowing that with the time and with the evolution of technologies, it's only fair that the ones that are meant to protect us are trying to use what is available there to achieve this work. And we've seen it in the past already with DNA. There's been case law of the court about the processing of DNA, conservation of DNA files. Now we move into new technologies and facial recognition. So now moving to facial recognition, where I need to highlight that the level of intrusiveness of the technology is extreme. This balancing of the necessity and proportionality is already, by definition, I think, very strong and important to consider. Jan Claesen and Yannick mentioned that the committee of the Data Protection Convention, which is the Council of Europe Convention, adopted just last week guidelines on facial recognition and data protection. It's not in the title, but it's obvious because it's a Data Protection Committee that adopted it. And so what I want to highlight about the guidelines, and you can find them online, is that it was adopted by a committee that gathers 55 countries. So it's not only our Council of Europe member states, it's also African and Latin American countries. And you can imagine the difficulty in reaching a consensus on such a text of such an importance at the moment, but we managed. It was unanimously adopted. And the other thing also, which is quite interesting about the committee, is that it's a mix of data protection authorities, so the supervisory authorities that we know in most of our countries, but also of government representatives. And there you can imagine that getting the balance right in the formulation of the principles was not easy, because you did not have only data protection experts going towards, just claiming the respect for the right to data protection. So I think that's an achievement. It was published last week on the actually 40th anniversary of our Data Protection Convention, Convention 108, and we're very happy to share it with you today. So I'm not going to present the guidelines in detail. What I want to start with is by highlighting that with the evolution to the right to data protection, following our realities, biometric data leading to the unique identification of a person is now considered as sensitive data in data protection law. It means you need a reinforced protection when you're using this data. That's a very important starting point. And then the guidelines, they basically target three groups. First, lawmakers, policymakers, insisting on and Kate, you recalled it, the lawfulness of the whole use of facial recognition technologies, really relies on the law that is actually bringing a restriction to one of our fundamental rights. And so the Court of Appeal the case you mentioned was very clear in highlighting what should be in that law for the use of facial recognition technologies to be lawful. So that's one first part of the guidelines. The second part of the guidelines deals with those that are developing the technologies, that are training the models, that are building the systems, and what are the data protection principles they should be taken into consideration. There, Yannick, you mentioned, of course, the whole audit and certification chain. That's becoming really key in that context. Finally, the last main target category of the guidelines is about the entities that are using the technologies. And there I should also say that the guidelines cover both facial recognition technologies used in the private sector and in the public sector, and you can imagine those are very different uses. So I think it's a highly relevant text that is there available for referencing and inspiration, and I'll just give you a few highlights which I think also respond to some of the questions I've seen in the chat. Because beyond the identification of our faces, facial recognition technologies can also be served to determine skin color, sex, race, age, health, and there is a strong provision in the guidelines that basically calls for a ban of those kinds of uses which have a high risk of discriminating the individuals. The other thing, and we're looking to the future, affect recognition is the new technology coming. You know, identification of our inner feelings, inner traits, even mental health. This is highly of high concern and should also be banned. So to conclude, just a word of the statement of our Secretary General, Maria Pejcinovic-Buric, that was issued last week. She said, at its best, facial recognition can be convenient, helping us to navigate obstacles in our everyday lives. At its worst, it threatens our essential human rights, including privacy, equal treatment and non-discrimination, and empowers state authorities and others to monitor and control important aspects of our lives, often without our knowledge or consent. So that was my introduction, and now, if I'm allowed, I would like to ask 3 questions to our 3 speakers that I thank again very much. And I will start by Thomas. I'll follow the order. Thomas, in your presentation, you insisted on the data appetite of machine learning systems, and twice you referred to collection, capture of data from social media. In the guidelines, precisely, this is one of the points we've tried to tackle, because from a data protection perspective, we see it as a real problem. And so the guidelines state that images available on social media cannot be processed to extract biometric templates or cannot be integrated in biometric systems without a specific legal basis for that. So if we take that into what you've presented to us, social media platforms that we're all using, and this example you've given about how you can actually poison the data yourself. Well, would you think that we should request the platforms that are enabling the publication of our pictures to enable by default our protection by setting in the machine a way for our pictures not to be used by, and I think it's Kate who first mentioned the Clearview example, but there are unfortunately many other examples of capturing of our pictures. So Thomas, would you think this would be a good data protection by design protection?
Yeah, I think it should be obligatory. Personally, in my opinion, I mean, technologically, potentially, companies will find a way around this, and it will be a cat and mouse game where they have to update. But I mean, a company the size of Facebook, they are leading the forefront of AI at the moment. They should be able to easily develop new strategies to obfuscate, we can say, our data on these systems. So yeah, I think it should. I think everybody should do it, and it should be a regulation for these online systems. I just wonder how you've mentioned this Clearview website or service, but there is I forget the name of it, but there's one in Russia as well, which is basically a reverse Google, where I can take a photo of somebody on the street and find out who they are just through their social media. So what is the regulation? Maybe I can ask a question back. If I find a service that's running in a state that hasn't signed up to your thing, am I allowed to use that in Europe? Personally, I wouldn't want this, but can a company just get around that by walking, in the protest, we talk about the police, but potentially a company, a social media company could walk around that protest to get a better picture of the political views of the people there. It doesn't have to be the police that are collecting this data. And then they can use some offshore means to identify the people. Is there some regulation to protect this?
Thank you.
Thomas, sorry to interrupt, Sophie. Just we have a problem with the camera of Thomas. So we hear him, but we cannot see him. So Thomas, for the rest of the webinar, if you can solve that, we want to look at you. So Sophie, for the introduction. I'll let you proceed.
No problem. Thank you, Thomas, for the question. And I think that only demonstrates why our work is essential, because precisely you cannot think nowadays with the technologies we're using, you cannot think nationally. We need more and more countries to abide by the same level of protection of our data, because we know data are flowing across frontiers. You mentioned a particular country, the Russian Federation, and I'd like to highlight that the Russian Federation has committed to our Data Protection Convention, and that the guidelines we're just now referring, even if they are non-legally binding, are clearly, we would hope, as a large community, a means to enhance the situation in all the countries concerned. And so the more countries will come committing to those principles and level of protection, and the more will be protected. So it's clearly a benchmark we're trying to reach there. Thank you.
Thank you.
Kate, you've mentioned all the conditions for the legality of what is an interference with our right to privacy and data protection, and the preconditions to legality. And so in light of this really high-level test of necessity and proportionality and level of intrusiveness of the technology, do you think that a just really strict limitation or ban on some types of use of the data, of the technology, should be recommended? And if not, at least a moratorium? And is this something that in Canada is being discussed?
It's a very good question. Right now, there are more questions than answers about the technology, and so it's hard to predict with a crystal ball whether or not it will be possible to arrive at a balance that is sufficient to protect the human rights that we all cherish and enjoy and don't want to see eroded by technologies that over time may slowly but surely weaken some of the democratic controls around policing that I think that we enjoy and potentially take for granted at times, and that's as it should be. And this question, it picks up on one of the problems that Thomas identified, is that without controls, just to pick up on what you were saying, Thomas, I've actually seen and I've seen reported on this idea that even with moratoriums or bans in certain locations, you see an end run around those limits. There was recent reporting just this week about how American law enforcement officials in cities that have bans on facial recognition can simply pick up the phone and call a colleague in a jurisdiction that doesn't have a ban and ask them to run the facial recognition processing. Similar dynamics we see in Canada, where we have strong privacy limitations from our constitution, but we also see that end at the border, and then Canadian law enforcement officials will pick up the phone and phone American counterparts and run very controversial technological interferences from a surveillance perspective. And so we need to think of it holistically and work together. If I could analogize the problem to sort of a PhD student who goes to a PhD supervisor and says, well, this is the method that I'd like to use to run this technology. This is my data set. It's policing data. It is data that was collected for 30 years and at a time where no one ever contemplated the use and repurposing of this data for a mass program. Rather, it's just data that police officers happen to locate as a byproduct of individual investigations. It's full of biases that we all know and recognize. It's full of discriminatory practices that have over-targeted Indigenous people and racialized people. We know that this data has these biases, but I'd like to proceed anyway. A PhD supervisor would justifiably say to the researcher, well, no, that's not a good methodology. Of course, you can't do that type of research, and it has very little value. Right now, we see law enforcement services that are seeking to use this data for new purposes that were never contemplated at the time that the data was collected. We also see that with private companies, there's a recognition that data protection and compliance is a very substantial cost of doing business. We see that with the GDPR. In Canada, for example, law enforcement officials have been given quite a lot of discretion with respect to data protection, to the point where concepts like data accuracy and data correction rights are very much a fantasy. You can't really correct data in a law enforcement database in any meaningful way. So we have this gap between the data protection infrastructure that's necessary. We know that the data set, such as arrest data, is fundamentally biased by historic discrimination. We very likely must recognize that certain types of uses of this data, without verifying that it's bias-free, it's a fundamental impasse. And unfortunately, that's the only data we have, so it may mean that law enforcement just cannot use it until new data sets are collected in the future.
Thank you. Thank you. And sorry, there's one part of the guidelines I forgot to mention, which is about the rights of the data subjects, just those rights you just mentioned on deletion, correction of data, and it's of course an important part. Sabine, last question is for you. Thank you very much for presenting this shift, this inversion of the approach, and moving away from a presumption of innocence, going towards automated suspicion. And you've quoted Article 6 of the European Convention on Human Rights. The right to privacy, right to data protection is Article 8. This whole legal instrument is about securing our human dignity, our human autonomy, and let's see how we'll continue to apply it in the future. Thank you for taking us also very precisely to the courtroom and start reflecting on what the questions would be. But so if I really project myself in this futuristic society with generalized automated driving, you mentioned the question of the witness, of the machine as being the witness, but what, and we have had the case of accidents occurred under automated driving, and so there you have the perpetrator that would be your witness, you would have the human driver. How would you conciliate all this? And are you following the discussions, and I think it's the case in Kahai, on the legal responsibility that is attached to those machines and those technologies?
Well, thank you. It's a big question, and I think it brings some things together. So first of all, I think, coming from criminal justice, that data protection and criminal justice, they are at odds. They are from different centuries in inquisitorial jurisdictions, and Juliette Leluer mentioned that we want to know it all if we go to the courtroom. It's a little bit more, might be more easier in a Canadian or a US courtroom. So that's always difficult to do. And that's why it's so difficult, I think, that we come with facial recognition to a model where we actually could force law enforcement not to use it if they already know it. So why wouldn't they use it? And I would also, I have to mention that now, listening to Thomas, to Kate, and to you, rightly, Kate points out that our data nowadays is biased. But the only way to enhance it is what Thomas mentioned. We have to get more data. The reason why young black females are falsely over-policed is because there's not enough pictures of young black females in the data set. Is that what we want? So I think there's a lot of things we ask for that we have to sort out. And now coming to my new robot witness, I think it's not so futuristic. I think it's already here. We just don't know a lot about it. There might be already insurance cases. Very rarely we go to a criminal court. And you can see that in the accident that happened in the US, the so-called Uber-Volvo case, where the car company does not face any criminal charges, but the human driver, she faces charges. And that's because I think it's so much easier to catch the human in the loop than to catch my robot driver. And I think we have to have a concept for that, because I think we will face that. And then, all the things come up that Thomas already mentioned, that the way the data is stored now, either in an event data recorder or on this DSSAD, that's all preset by the car company. So it's an engineered witness. It's not a neutral witness. And we have to have answers for that. And, there will be different answers in a US or in a Canadian jurisdiction or in Europe, but we shouldn't wait too long, and we shouldn't think it's too futuristic. That's why I took us all the way to the courtroom. Thank you.
Thanks a lot. I just want to mention that I just pull to the chat the link to the work of the Committee on Data Protection, with a link to our website to these guidelines. And thanks a lot also for the question into the chat. I would like now to switch to our master and PhD student of the University of Strasbourg. They follow our question, they follow your intervention, and I'm pretty sure that they have questions to raise now to our distinguished guest. Yamina Bouhadi, are you connected?
Yes, can you hear me?
And yes, you can take the floor. We hear you for the moment, but I don't see yet your face.
There is the same camera problem like with Thomas before, but that's okay, we see you.
Okay, perfect. Good afternoon, everyone, and thank you, Yannick, for giving me the floor. So I had the chance to write my thesis last year, my master thesis last year, about AI and criminal law under the direction of Juliette Leluer, who is here. And I will now raise my question on a more global view of the use of facial recognition in criminal justice, after having a comparative view of this use in countries. So as far as I could understand, facial recognition can be used in courts as evidence where images from police authorities were taken. So, and I've understood that there is two main approaches. The first one, who is the identification of a specific person in a crowd, for example, and the second one, which is a massive surveillance in cities, and which Professor Sabine Adles explained that could produce suspects. And on a comparative view regarding identification of targeted individuals in crowds, we already know and mentioned that some tests and true operation already took place in countries, as we also saw in the Sky News video at the beginning of this conference, where in the UK, for example, in South Wales, there is police officer who have watch lists of suspects. And I could also cite the example of France, of the city of Nice in France, who experimented a test of identify suspects at the entrance of events, so to identify specific persons in the crowd. Sorry. However, its rates of success depends on the operation itself and on the country's regulation. And in EU member states already have strict frames when it comes to facial recognition in public spaces, as Sophie could highlight it. And the risks of bias in these technologies are also taken into account and must be taken into account in the regulations. And my point was that in other countries, as China, for example, massive surveillance and massive surveillance is more used as the politic of social credits, for example. And my question is that my question might be maybe utopian, but do you think that it is possible to reach a worldwide balance between freedom and security regarding facial recognition and its use by criminal justice? So yeah, and do you think that in years to come, some courts will join the position of the Court of Appeal of London, for example, which taken into account the role of facial recognition used by police, for example? Thank you.
Oh, thank you, Yamina. I suggest that our three experts answers in the same order than before. So Thomas, you could take the floor as first.
Yeah, it's a very good question. Is it possible? I mean, from a technological point of view, there's nothing. I mean, it's a technology. It can be used to identify people, but it's the use of the technology that's the problem. The model itself, which is the work that I do, is not is ambivalent. Yes, it doesn't have an objective as such in the real world. I think one of the points that should be made is that that I presented a deep learning approach, but within that there are hundreds or thousands of variations of this approach, and each one has certain strengths and weaknesses, and there are other approaches before deep learning that are definitely can be stronger or less robust in certain cases. So I think the problem thinking about it worldwide is that I imagine that there are going to be countries that have a very outdated technology, and some that have a very up-to-date technology. So there's not going to be an even playing field throughout the world. But in terms of whether it's whether there's going to be a balance, I think it depends on people's opinion on the technology, and I guess that depends on the regulation. Personally, I wouldn't like to be monitored throughout the city in my everyday life. If there was some argument that could be found in the future that there is some great benefit to society for this, then perhaps I could sign up to the idea. But at the moment, I don't see this. Very much for the question.
Thank you, Thomas. Kate, you can just follow up. Yeah.
I think there's a couple of different types of conversations we could have to answer the very good question. One of them is that this is a political discussion. Technology is a political tool, and how the law responds may be different than how, as a democratic discussion, we would respond to the risks and dangers ahead. There's this concept of Techno Solutionism, which is this idea that because a technology, it's kind of bright, shiny, it has this sort of great promise that is touted by either the vendors of the technology or the police agencies that hope to be able to make use of it, they'll highlight the potential benefits. I think from a democratic perspective, what we expect from law enforcement and how what tools we give to law enforcement will also be defined by what are the goals that we're seeking to achieve. And if it's to address the harm that criminal justice processes are trying to reduce, to protect individual safety and to help reduce the level of crime in society, we already have a great deal of expert knowledge from criminologists about true sources of crime and some of the systems that we need to invest in to actually address and remedy the true goal that I think we're all working towards. For example, when we think about investing in trying to correct broken technologies as opposed to investing in a mental health care system, you might actually find that alleviating some of the strain of underfunding mental health care in society may be more useful. And so technology is not always going to be the answer from a policy or political perspective. But also we might want to think about how when we as government agencies invest in technologies, we also want to think about the worst case scenario of who becomes able to use these technologies. We've seen in national, as an organization, the Citizen Lab at the University of Toronto has done quite a bit of research and highlighting the relationship between the development of very powerful national security surveillance technologies and how those are often repurposed and moved sort of from a gray market to a black market to be used by repressive regimes. And we are already seeing problems in China with respect to the mistreatment of the Uyghurs and how facial recognition systems are being used there. And so both governments and private companies will want to think about how they're creating technologies and who they may be used by in the future. And so it's a very complicated dialogue, but I hope that helps kind of contour some of the tensions that you've well identified in your question.
Thank you. It's a very difficult question. And I think if we look back in history, it's very rarely that we had a worldwide agreement on that something should be not used at all. But we have it with torture. In torture, we have agreed that it's so inhuman and so untrustworthy and so unfair that we don't want to use it. And actually, I don't think we are not there with facial recognition. I think, and you could see that in our presentations, people debate whether it can be enhanced, made better, and then it would have better results. But at the same time, we have seen in the presentations that we are afraid of if it's really very effective and can have a even more chilling effect than it has now. So I personally think we are not there yet that we could find such an agreement. Thank you.
There is still a lot of work to achieve, definitely, and the Council of Europe has the big charge of improving the legal situation. So now we turn to Sylvain Vernas-Beaugrand, who is a PhD candidate at University of Strasbourg, and I'm sure Sylvain has another interesting question. So, Sylvain, do you hear me?
Can you hear me?
Yes,
Perfect.
very good. So,
Thank you, Juliette, and hello to everyone. First of all, thank you to the three speakers for the really interesting presentation. To introduce quickly myself, so as Juliette earlier said, I am a PhD student in criminal law at the University of Strasbourg and Basel, notably under the direction of Sabine Gleis. From all I heard, what stands out is that AI can make fake evidence. So during a trial, we will have to question the evidence that comes from AI, particularly the reliability of the pieces of evidence. Sabine Gleis, you said that we will need to have experts in court, and Yannick Menesser said that it will remain difficult because with AI, nothing is clear. My opinion is that, in fact, in addition to the experts, we will have to impugn the method. If we want to impugn the methods of AI, we will need to get access to the code behind the AI. And this raises lots of problems, particularly from the point of view of industrial secrets. It will be all the more difficult to get this access when the company which holds this code is abroad. So my questions are the two followings. First, would it be legally possible to get an access to the code behind the AI? And if yes, in what ways should this access be achieved? Do we already have any solution in Switzerland or in Canada? And the second one is, do you think that such a procedure should be part of a supranational instrument, so to make sure that we can get access to the code when needed for a trial? Thank you very much.
Thank you for the interesting question. So access to the code, there's a slight difference, just to point that out. The code where something runs like a program is in AI is slightly different to the model that is learned. So the code runs and learns some representation, and that is actually what classifies things. How to understand that? It's very difficult. Going back to this about experts in the courtroom, and one of the problems with this is that AI is going to become very pervasive in our lives, and to have an expert available on hand for every kind of evidence is I don't think it's possible. I work with I have over 10 years of experience working with AI, and I work with my PhD students every day. I work in medical imaging primarily at the moment. So I'm using these deep learning systems for medical images, and we sit down there for hours discussing with each other, trying to find out why a model is making the decision it is. And we don't know precisely why it's making that model. In fact, to understand the model is like a little detective game in its own self. We sit there, we test it with different things, we try and visualize things and look at things and delve inside it, and we can get some evidence to support the hypothesis why a decision was made, but we can't say exactly for certain why that decision was made. So in current technology, if we're using deep learning, you would have another little detective game in the courtroom, and that would be it. So you'd have to have access to the model, the trained model, the weight as we call it, and you would have to spend a long time analyzing it, probing it to find out what's going on and why it made a decision. There is research now. This is called Explainable AI. So this is the next thing that's being worked on and very popular at the moment. And I mean, deep learning is the current state of the art. It doesn't mean that in 20 years' time this is going to be it. There's going to be some other models that work things, and perhaps they are going to be a lot more explainable and a lot more logical to understand. So potentially we won't need experts. Maybe they will just explain themselves and give a nice report where everything is or maybe it's a bit fantasy thought, but that's what research is moving into at the moment. So potentially we can remove this need, and we can just tell the company you have to give a report with this decision, and the model explains with the evidence nicely organized how it works. Maybe that's not going to happen, but that's what we're working on at the moment. Thank you for the question.
I will continue with Thomas's great and helpful answer. As researchers, we identified in our report with respect to algorithmic policing technology that accountability mechanisms like transparency is a necessary but not sufficient protection for human rights. In criminal justice, access to information about the algorithm that's being used is one of what would need to be a system of procedural fairness that alleviates individual defendants from wearing and shouldering the burden of showing the absence of reliability of an algorithm. And so we really try to think of it as a system-wide system of fairness, so that other human rights watchdogs, academic researchers, experts can assist in shining a light on the reliability or unreliability of a particular algorithm that might be used. We've recommended in our report that we follow the model of some cities such as Seattle in Washington that have enacted directives that constrain governments, including law enforcement, their ability to procure technologies like algorithmic policing technologies, unless they the source of the algorithm, the vendor, is willing to satisfy certain preconditions. And so we can make open source code one of those preconditions. And if there's some national security reason why publishing the source code can't be done, then there should be parameters established so that academic researchers can have access on a confidential basis, so that research can proceed even if it's not fully published. In Canada, we've also seen that law enforcement services have been slower to adopt some of the controversial technologies, such as the predictive policing programs that we've seen developed in American cities. Some of the human rights dangers associated with those technologies have come to fruition already, and we've seen some of the cities such as LA and New Orleans and Detroit, or Chicago, sorry, walk away from some of these programs. I think that Canadian law enforcement has been observing some of those lessons learned, and they've moved towards a model of developing algorithms within government, so that it's not a private sector vendor that holds the keys to the source code. Or we see a partnership between a university academic program as well as law enforcement in another province, where you see the development again of an algorithm through that type of partnership, so that some of the proprietary claims over secrecy that the private sector may assert don't have an opportunity to interrupt already what is the sort of complex black box problem. So you could either establish procurement directives to restrict the purchase of private algorithms, or move towards investing in public sector versions of these tools. I think both still lead to an insufficient result, which is you still might wind up with this black box problem. The knowability of an algorithm, it has its limits, but these are some of the safety valves that we can turn to try to alleviate the problem. I should say as well, I mean, we have already in Canada, not as much with facial recognition, but with DNA analysis and algorithmic analysis of another type of biometric information, which is DNA. It's called probabilistic genotyping. We've already seen courts deny defendants access to even the validation studies that our forensic laboratories use to verify whether a private sector algorithm called STR-mix is a valid tool for use in criminal justice systems. And we've seen many prosecutions proceed even when this information hasn't been disclosed. So it's very troubling, and I hope to see some of our recommendations adopted by governments.
Thank you for the question. So I think, you asked for legal tools to address the problem. And I think various already came up in Thomas and Kate's answer. The first option would be to just say, this is not reliable evidence. And that could be, in the US, in Canada, but also in France, in Switzerland, you could say that. And I think, as Thomas pointed out, we will have a lot of artificial intelligence monitoring humans. And with many of the applications, we will think it's not reliable. Again, I come back to my driving assistance. I think we will have a lot more trouble to say it's not reliable. And there, you could go, you could ask for source code, training data, and everything. And I agree with Thomas that it would be very difficult to show why in a certain situation, a particular driver has been identified as drowsy when actually this person has been very alert. So, and that already was mentioned by Thomas, one option could be that you ask the company to show a protocol and somehow try to make sense of what happened. But with deep learning, that will be no option. So the other option could be that you go and you have sort of failed protocols. The program or the car producer has to show how reliable the tool is. Again, that will be very difficult with drowsiness, a lot more easier, like with DNA, that's easier, or measuring your blood alcohol, that's a lot more easier. But we have to come up with an option. And I think the best thing is the people who put it on the market, they should test it, they should show reliability. And if they cannot show reliability, we just cannot use it. And then we come back to Yamina's question. Will we be able to do that, refrain using it? That is to be seen. Whether worldwide we will have some reasoning that, we just cannot use it because it's unreliable. Thank you.
Oh, thank you. Thank you very much. So these were very interesting questions, and I think there has been a very good dialogue between all of us. We are now reaching to the end of our session, but before closing it, maybe some of you want to join the poll. We have 15 persons participating to the poll, so if some additional person wants to give their opinion, that would be very good. I'll give the floor to Yannick for some conclusive words, and then we'll see what our audience has said for the very end of our session.
Yeah, thanks a lot, Juliette, indeed. We'll have some minutes to conclude, because this final question is for me interesting. It's a kind of conclusion now of all this discussion. Would you support the use of facial recognition in public space? We have choice with 3 options. I'll let you answer. Just with a very short word of conclusion now about facial recognition. There is something that strikes me, and it was not mentioned as such, is that the use of technologies in criminal field is not new at all. I can start there, but I can start before with Alphonse Bertillon in France in 1902 with fingerprints, DNA in middle 80, use of course of video surveillance. All this technology were used then in criminal cases. But there is a common point between all of that. This technology are not used without a strong legal background, and this strong legal background is also the result of a democratic discussion. And maybe Claudia Luciani, who cannot reach us now because there is a debate actually at the Committee of Ministers about artificial intelligence and the KAI, so I had to excuse her because she cannot be with us. But I think she could support this view that now this democratic debate must be open to construct law about that. I saw, and maybe you saw that in December, the last AI&Law webinar, where there is this scientist from Stanford who showed this use of physiognomy. Physiognomy was well known, and if you scratch a little bit, everybody remember that in criminal field, Cesare Lombroso has used already this kind of point. And it has been refuted. And now with another mask, the mask of artificial intelligence, we see a resurgence of such facts. So to conclude, I think we need more and more law and democracy, and this facial recognition system raises questions that we are already used to deal with, but again, with a strong legal and democratic background.
Thank you very much, Yannick. Thank you very much for being the voice of the Council of Europe for our conclusion. Now, do we have some more?
Yes, the result, there is 30 participants, so statistically, I cannot rely strongly on that result, but there is an answer at the question, would you support the use of facial recognition in public spaces? All of our audience, 53% say no, and there is 42%, maybe there is some votes that comes, but still, yes, there is a need of a new legal framework. So we may conclude that this is a balanced opinion at this stage, and even if this participation maybe is not representative as such, but the debate is open, and I think we can thank warmly Thomas, Kate, and Sabine again for the support of the work of university and the Council of Europe, and to disseminate, to see that these questions are maybe complicated on one hand, but thanks to you, I hope it's more clear to a lot of our participants. Thanks a lot for that.
Thank you from my side too. Thank you to all participants and especially to our three experts. And we'll see each other again in April for the next webinar. Goodbye.
See you. Goodbye.
Bye.